Since the 27th of March 2020, police say nearly 500,000 South Africans have been arrested for breaking lockdown regulations under the country's Disaster Management Act. Many of these cases include people not wearing masks in public, breaking curfew or violating the booze rules. But enforcing the regulations has turned deadly in the past, with soldiers, for example, allegedly using deadly force against Alexander resident Collins Khoza in April last year. It's incredibly crucial we know our rights during this time. So we've roped in a legal researcher, Edwin Makwati, to assist us with a lockdown refresher course. Edwin, thanks a lot for joining us. So what are your rights if you are arrested for violating COVID-19 regulations? What's the first thing you do?
Thank you for having me. The first thing that I would like to say is that because now it's about breaking COVID regulations, the rights of arrested persons do not change in any way, because the cardinal point of reference is the Constitution, Section 35, and obviously the applicable provisions of the Criminal Procedure Act, which deal with the rights of arrested, detained, and accused persons. The first one is that you have the right to remain silent and not to make any confessions or statements. You have a right to legal representation of your choice, to speak to your lawyer if you so wish. And you have the right to be brought before a court or tribunal within 48 hours. And if the 48 hours falls outside of the normal court days, on the next earliest date after that. So there is no material difference between the normal constitutional rights of arrested persons during during this COVID time. So it's just that people got to know their rights by obviously referring to the Constitution and other provisions that are there in the Disaster Management Act, and of course the Gazette 44772, which was signed on the 27th of June by the minister.
Edwin, say you are arrested and you ask to immediately speak to a lawyer or see a lawyer. What happens if you are refused that request?
There should be complaint mechanisms within the system. Obviously, many times police do deny people the right to speak to their lawyers, or deny them certain rights that they're entitled to. The first thing that you have to do when you get an opportunity is to launch a case within the station with the station commander himself, or go to the provincial office of that particular police department. That is when you can have someone who can advise you on what next steps to take if you want to go the civil route and sue the police for denying your rights. Because you see, the rights in the Constitution can only be limited by the Constitution itself. That is Section 36 of the Constitution, which states that any limitation should be by law of general application in an open and democratic society. So it is not something that can be willy-nilly done. So you have those mechanisms within the police department. You follow all the steps until you get to if the Minister of Police, then you got to get there. And obviously you've got the civil remedies applicable to you, which you can use to sue the police that denied you your rights to speak to your lawyer, because it's a fundamental right.
Edwin, one of the ways that this police brutality has come to light is that people have cameras on their phones now, so they're able to take videos and it's documented. But a lot of the times we see police, not just here in South Africa, across the world, telling people not to take videos or stopping them from taking videos. Is it your right to record something that you see that seems like police brutality? And if they tell you to stop, do you have to stop?
Not at all. You know, police who tell people to stop are thugs, because the reason they're telling people to stop is because they know what they're doing is criminal. So you have the right to record any incident of police brutality that you see, and to produce that evidence if it's needed going forward. Let's say, for example, when there's any litigation that ensues after that. Should the police take your cell phone and delete the videos or any kind of that sort, still you can sue them for invasion of privacy, because your gadget is your personal property.
Yeah.
The only thing you should not do is to obscure police in the performance of their duties, e.g. standing between them and the person they want to arrest, or stopping them from doing whatever they want to do in executing their duties legitimately. But to take a video is not an offense at all.
Absolutely. Edwin, thank you so much for your time. We really appreciate it. Edwin Makwati from the Legal Resources Center, thank you so much for your time this morning.